Ladies and gentlemen, before we begin, and we all are very aware and saddened by the loss of life, the incidents that occurred yesterday. It's our understanding that there are right now children and families that are gathering at the school. So if you would, let's take a moment of silence in memory of those. Thank you. We will be beginning here very shortly, so please bear with us. It is 12:05 on Tuesday, March the 28th. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representatives Campbell, Davis, Gillespie, Hardaway, Howell, Halsey, Johnson, Lamberth, Moody, Russell, Sherrill, Towns, Chairman Doggett.
Present.
Chairman Doggett, you have a quorum.
Thank you, ma'am. Members, do we have any personal orders before we begin? Seeing none, we're going to jump right into the calendar. Item number 1, House Bill 994 by Chairman Kiesling will be rolled to the Hill. Item number 2, House Bill 555 by Representative Littleton. Motion. You're recognized. There's Amendment Code 5357. You wish to proceed with that amendment?
I do.
You are recognized on the amendment.
It does make the bill.
Okay. Would you like to go ahead and attach
Please.
that? All right. All those in favor say aye. Those opposed, ayes prevail. We are now on House Bill 555 as amended.
Thank you, Mr. Chairman and committee. Current law hinders the access of victims of human trafficking to accessing the Criminal Injuries Compensation Fund due to the unique nature of their crime. Proposed legislation was drafted by the Treasurer's Office after multiple conversations to allow victims of human trafficking the same opportunities as other victims to access the Criminal Injuries Compensation Fund for pain and suffering.
Thank you very much. Any questions for the sponsor? Questions been called. Any objection? Seeing none, we're voting to send House Bill 555 on the full criminal law. Those in favor say aye. Those opposed, ayes prevail. You move forward.
Thank you, Mr. Chairman and committee.
Item number 3, House Bill 398 by Representative Littleton. You are recognized on the bill.
Thank you, Mr. Chairman. This bill requires a court to order mental health evaluation and treatment for juveniles who commit aggravated animal cruelty to a domesticated dog or cat, and authorizes a court to punish a parent or guardian in contempt of court for failure to comply with required court order.
Any questions for the sponsor? Questions been called. Any objection? Seeing none, we're now voting to send House Bill 398 on the full criminal. All those in favor say aye. Those opposed, the ayes prevail. You move forward. Item number 4, House Bill 1106 by Representative Littleton. You are recognized on the bill.
Thank you, Mr. Chairman and committee. This authorizes a juvenile court to transfer a child who is 16 years of age or older to adult criminal court for committing the offense of escape from a youth developmental center.
Very good. Any questions for the sponsor? Questions been called. Any objection? You withdraw. Representative Towns, you got a question?
I do, sir. Thank you. Now, when we're transferring the child, they're not being transferred to adult courts, are they? When the child is being transferred, are they going to be transferred to adult court? It's a 16-year-old, I believe you said.
Yes, they are. But they've been charged with the offense of robbery or attempt to commit robbery, confined to a youth developmental center certified, licensed by the Department of Children's Services.
So they've been charged. Go ahead. I'm sorry.
So they've already been they've already been charged and convicted of felonies.
And they're in a youth facility, and then they escape. And okay, got it. Thank you for the explanation.
Any other questions for the sponsor? Seeing none, we're now voting to send House Bill 1106 to full criminal. All those in favor say aye. Those opposed, ayes prevail. You move forward. Staying with the Littleton calendar, we'll go to item number 5.
Thank you.
House Bill 1400. You're recognized. There's an amendment code 5367.
Yes,
You're recognized on the amendment.
it does make the bill.
Let's attach the amendment to the bill. All those in favor attaching amendment code 5367 on the full, onto House Bill 1400, say aye. Aye. Those opposed, the ayes prevail. You adopt. We're on House Bill 1400 as amended.
Thank you, Mr. Chairman. This requires the sentence for a person convicted of rape be no less than a sentence imposed for a range 2 offender if the victim of the offense is at least 13 years old but less than 18 years old, and it enhances the penalty for incest if the victim is a minor from a Class C felony to a Class B felony, and requires the sentence for a person convicted of incest to be no less than a sentence imposed for a range 2 offender if the victim is a minor.
Thank you for the explanation. Any questions for the sponsor? Questions have been called. Any objections? Seeing none, we're now voting to send House Bill 1400 as amended on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move forward.
Thank you, Mr. Chairman and committee.
Item number 6, House Bill 279 by Representative McKenzie. Without objection, we'll roll to the Hill. Item number 7, House Bill 1256 by Leader Camper. Roll to the Hill. Item number 8, House Bill 1166 by Representative Glenn. You are recognized.
Thank you, Mr. Chair and members of the Criminal Justice Subcommittee. This bill here aims to fix an injustice that occurred here in the state of Tennessee. A resident who was sentenced to 6 years in prison for trying to register to vote. The case attracted national attention because of the severity of the sentence. This Tennessean had no idea she was ineligible to vote. She had taken all steps to restore her voting rights in the state. The whole situation stemmed from a government official's error, but she was the one held accountable. She had completed her prison sentence in 2015 felony conviction when she sought information in 2019 on her voting eligibility. To restore rights that she said she did not know she had lost when she pled guilty. The Correction Department and the County Official Commission both signed off on her voter registration application in 2019, certifying that her probation had ended, granting her full voting rights once again. But there was a problem. The officials who signed off on her being eligible to vote acknowledged that they made an error in saying her probation was over, meaning her voting rights had not been restored. So when she submitted the certificate as part of her voting registration, she was charged with trying to illegally vote, register to vote. After she was convicted of the voting error last November, she was sentenced last month to 6 years and 1 day in prison. She maintained that she thought her voting rights were restored when she received a letter saying as much. An email made public by the Guardian showed that a Tennessee Department of Correction probation officer admitted they did not do their due diligence when he told her probation sentence was over, when it was not. The email detailed in the finding of the internal investigation into the error. It revealed the probation officer failed to cross-check records, which led to the misrepresentation in her probation period. Her attorney said that he had never seen the document before the Guardian showed it to him in last February. The judge who oversaw the case and sentenced ordered a new trial, citing the prosecution's failure to disclose the letter, even if it was inadvertent, as one of the reasons he was ordering a new trial. Under current Tennessee law, a person convicted of a felony is eligible to apply for restoration of voting rights upon receiving a pardon, discharge from custody of service or expiration of maximum sentence, or being granted a certificate of final discharge. A person is further prohibited from eligibility to apply for a voter registration card unless the person has paid all restitution to the victim of the offense, all court costs associated against the person for a trial, if the applicant is not indigent, and all child support obligations. Once conditions are met, an eligible person may request a certificate of restoration of voting rights to be submitted to the administrator of election in the appropriate county. So what this bill does, it would create a process for implementation of a certificate of registration of voting rights without requiring action by the person eligible for reinstatement. The bill would eliminate any suspicion of voter fraud or malice intent by removing the applicant for restoration from the chain of custody entirely. This bill established statewide uniformity in the certificate of registration process, which significantly reduced to practically eliminating any error on behalf of our state and local agencies. This bill creates efficiency among government agencies by streamlining the process for restoration process. Mr. Chair and members, I thank you and I ask for a favorable vote on House Bill 1166.
Thank you for that explanation of your bill. Are there any questions for the sponsor, Representative Johnson?
Thank you so much for bringing that bill. What you explained was just a travesty. And so your legislation would address that and ensure that that is not going to happen again.
Correct. That would take the person out of the process, and everything would move without the applicant actually touching the document.
But it doesn't really change any of the requirements or any of that. It just removes that from the process. Doesn't make them responsible if somebody else doesn't do their job.
Absolutely.
Okay. Thank you.
Representative Towns.
Here again, thanks for the presentation. The person that this happened, what was the ultimate verdict or decision for that particular person?
They are pending a new trial now.
So the trial is pending now?
Correct.
Oh, wow. Scheduled for when, do you know?
No, I do not have that.
All right, very good. Thank you.
Any other questions for the sponsor? Leader Lamberth.
So I understand what we're trying to do, and I appreciate you sharing with us the specific circumstance. I'm still trying to figure out exactly how that matches with this, but I will admit I walked in as you were in mid-presentation, so you probably covered somewhat this beforehand. In subsection C of this, unless there's an amendment here, it says that the local election commission is to contact the individual, provide assistance to registering to vote. I mean, they already do that. What more would you envision as part of this?
Thank you, Leader. There's nothing changing as far as the person himself or the entities in terms of the process. The process itself doesn't change, with the only exception of the individual will not be taking the certificate themselves. This is where the issue happened. It looked as if it was voter fraud by her taking the document herself, whereas this process would eliminate any errors that occurred in the process.
Well, my issue with that is that we've got a $192,400 fiscal note here to the locals, and I've never been a big fan of unfunded mandates. There should be a state entity that could do what you're describing, and then I think we would be in better shape. So my only reservation on this is that we appear to be hoisting something on the County Election Commission. They already allow folks to come in and register and everything else, and the circumstance you described sounds relatively unique. I'm just not comfortable requiring them to be the ones that do it. If the state's going to force this, and I want this to be as streamlined and easy as possible for anybody without error, it, to me, should be a state entity that is doing this. The Secretary of State, someone else. But that's my only reservation. Thank you.
Thank you, Leader. I will tell you that I actually went and talked to my county election commission, Miss Elizabeth Black, on Friday about this bill. She is totally in favor of it. She felt that it was a really good bill, and it really and truly eliminated any missed errors that may take place from hand to hand versus the individuals who are responsible taking on it.
Thank you. Chairman Holsey.
Thank you, Chairman. I came in halfway too. I had another bill across the hall. Just to make sure I'm understanding perfectly, this doesn't change state law at all as far as the requirements before you can get your voter rights back. You still have to go through the process. You still have to serve your time. You still have to pay your fines and fees and restitution and all that. It doesn't change any of that. It just lays the burden of informing somebody at the election office. Am I saying that correctly?
Absolutely, Chairman. That is
Okay,
it.
thank you.
Anyone else? Any other questions? I do have one. It says in here in section C that the county election commission shall contact the individual. If they do not contact the individual, what is the repercussions of that?
There are no repercussions. The individual will know that the process is taking place. The shall is just keeping them informed on where they're at in the process.
Well, it says that they shall contact the individual to provide assistance to the individual with registering to vote. So if they do not contact the individual, then there's no repercussions for that?
No, None, Chairman.
Okay. Any other questions? Representative Towns.
So, Mr. Chairman, what I'm hearing is more like we're encouraging them to contact, or they're encouraged to do it, but there's no penalty if they don't do it. And chances are those election commissions will work with us and try to make sure. It's not going to be that many, I would imagine, across the state when you break it down into however many election commissions we have, 95, 90, whatever, you know. But it encourages them to do so. And I think the bill makes a lot of sense, you know. Unfortunately, this happened to that lady, or whomever it was. I'm always of the opinion, as soon as people can get back on track, having a full life restoration, the better off they'll be for themselves, their family, and our community. So I appreciate it. Thank you, Mr. Chairman.
Thank you. Representative Howell.
Thank you, Mr. Chairman. I guess I'm sitting here trying to figure out how this will work in reality. The local election commissions, and there's 3 in my district, are thinly staffed. They work on a very strict budget, and I'm wondering how are they going to receive this information that a former inmate's rights have been restored? Where are they going to get that information? Because they're not in law enforcement.
Correct. Thank you, Mr. Chairman. Nothing changes. So you go into the election commission and you ask for the paperwork or the process to restore your voting registration. The election commission will then send it to the appropriate authorities themselves. The individual will not carry that paperwork. The election commission will send it to the appropriate authorities based on the information you give them. Once they send it to your probation officer, whoever, they sign off, and then they send it back to the election commission for you to be restored. The chain of custody is no longer in your hand. That way it eliminates any fraud of you doctoring the paperwork or anything like that. Does that make sense?
Thank you, Mr. Chairman.
Thank you. Representative Davis.
Thank you. And so back to kind of Chairman Doggett's question about that shall language, if the election commission fails, can that person then sue for not having their rights restored or that paperwork not turned in properly, or would they not have some sort of civil litigation against our community?
Thank you, Representative Davis. No, nothing changes. I mean, you can't sue someone now for, not processing your paperwork in a timely manner. I mean, you can't sue for that now, so nothing changes.
Any other questions for the sponsor? Representative Howell.
Thank you, Mr. Chairman. I'd like to follow up on my colleague, Representative Davis. That does bring up a question. If there's a big difference in bills about may or shall or will, and anytime there's a shall, it gets my attention. So this is a mandated thing that this election commission has to do. And as we all know, anybody can sue for anything, whether it's in civil court or whatever. But I have a concern about that. I don't know if there's a way to address that with an amendment or what, but I have a concern about that myself. Thank you.
Thank you. Any other questions for the sponsor? Seeing Representative Towns.
Mr. Chairman, I'm apprehensive and I'm very, concerned as well as it relates to a citizen trying to get their lives back together, and as a body, if we can look at what is necessary to ameliorate this piece of legislation, that we ought do that in order to give that particular person or persons an opportunity to do just so. Many times when stuff is drawn up, you all have been here a long time, some of you have. The wording is, and our people do a great job, superb job, but the wording is not adequate. And the committees many times improve these bills. So what I'm going to ask is this, Chairman Lambert, okay, and others that are here, that we need to look at if this bill needs to be rolled and amended and tweaked where it accomplishes what the gentleman is trying to accomplish, that we do it, because we have on the other side of the equation, you got a real human being that's trying to repair, restore themselves, and our knowledge, may need to be added in this equation. So at this point, Chairman Lambert, I'm deferring to you on what we can do to try to accomplish what it is I see that Mr. Glenn, Representative Glenn is trying to accomplish.
Thank you, Leader Lambert.
Now, Representative, it's been many years since I was chairman. If you were to ask for someone's assistance, I would recommend it be Chairman Doggett's in this particular circumstance. So we served several years in which I was your chairman. I was honored to serve in that capacity. But at this current time in Tennessee history, Chairman Doggett would be who I would refer to if you were looking for assistance in this particular endeavor.
Representative Towns.
Well, the great leader has referred it to you, and I can suggest, Leader, as well as Chairman Doggett, that we look at it for a week and see if we can put something together that may help us, tweak it, because I hear what Chairman Howell and some of the others are saying. Let me just motion that we move it a week so we can actually look at it.
Second.
Okay.
We can't roll it a week. This is our final calendar.
Oh, is the final calendar?
Yes, sir. Yes, sir.
Chairman, how many bills do we have on the form today? No, how many bills?
42.
Okay, 42 bills? Okay, well, let me suggest that we roll it to the Hill then and give us an opportunity to try to tweak it today. Okay, we may get to 42, we may not, but let's roll it to the Hill, Mr. Chairman.
Without objection, roll to the Hill.
Okay. I didn't get with him.
Thank you.
Item number 9, House Bill 574 by Representative Hemmer, roll to the Hill. Item number 10, House Bill 1233 by Representative Hemmer, roll to the Hill. Item number 11, House Bill 1126 by says Leader Cheryl here. Yeah. That's okay. You're recognized, Leader.
Thank you, Chairman and members. House Bill 1126 is brought to us by our local judge in White County, and where this is a issue with dogs running at large and maybe going over to the neighbors and killing their chickens or whatever they're killing, and he's asking that he can ask for restitution for damage to other people's property.
Any questions for the sponsor? Questions been called. Any objections? Seeing none, we're voting to send House Bill 1126 on to full criminal. All those in favor say aye. Aye. Those opposed, ayes prevail. Hey, thank you. Item number 12, House Bill 832 by Chairman Halsey. You're recognized. There are 2 amendments, Chairman.
Yes, I'm sorry. Let me get my book out. Yes, Chairman,
I have Amendment 5925.
Motion amendment.
You're recognized on the amendment.
And I have Amendment 832, if you want to take them up together or vote on them together, or...
You repeat that. I'm sorry. I missed that, what you just said.
You want to attach them to the bill first, one at a time?
So you've got 2 amendments?
I have 2. That's the only one. Mr. Chairman, House Amendment 5725.
5925?
That, I can't see, that's a correct.
Does anyone have some glasses that we could
Yeah.
share with the chairman?
I told somebody I was dyslexic a little bit. I did join an organization called DAM. It's Mothers Against Dyslexia. I'm trying to get over that.
Question on the amendment.
Question's been called on the amendment. Any objection? Seeing none, we're voting to attach Amendment Code 5925 on the House Bill 832. All those in favor say aye. Aye. Those opposed, ayes prevail. You adopt. Chairman Halsey, explain your bill as amended, please.
Thank you, Mr. Chairman. And what this bill does is folks that have been put on the sexual registry list because of back in the 90s when we passed the bills dealing with HIV and AIDS, that if you transmitted that disease either intentionally or not intentionally, or consensually or not consensually, that you can be charged with a Class C felony. This bill doesn't take away that charge at all. But we ended up putting these folks on a sexual registry list, which, in my opinion, it's not for that. It's for predators. And at any rate, you have folks coming out, particularly people who are in a trafficking situation, and they've come out of that, and now they have this sexual registry that it's 10 more years before they can ever get off of it. So what this bill does, it says that effective July the 1st of this year, if you're charged with this, you won't go on the sexual registry list, and if you've been charged prior to this, you can make an appeal to come off the list. That's what it does.
Thank you for that explanation. We do have testimony here today, I believe. No? Zoe? Jamil? I'm sorry if I...
Question on the bill.
All right. Question's been called. Any objection? Seeing none, we're now voting to send House Bill 832 as amended on the full criminal. All those in favor say aye. Aye. Those opposed, ayes prevail. You move forward.
Thank you.
Item number 13, House Bill 908. Vice Chair Gillespie. Okay. If you'll disregard that, we're going to roll that. We'll roll House Bill 908 to the hill. Item number 14, House Bill 830 by Vice Chair Gillespie will roll to the hill. Item number 15, House Bill 96 by the one and only Representative Hardaway. You are recognized.
Thank you, Mr. Chairman. And House Bill 96 is not ready for prime time. I promised the CJP that before I proceeded that I would get with them and get approval on the language of an amendment. So I would love to roll that to the hill or close.
Well, Representative, it has not been calendared in Senate Judiciary, and from what I understand, they are on their final calendar.
Well, if we roll it to the hill, and we'll have it for an option if we have nothing else to do this year. But just in case they do decide to do something over there. Because I would really like to put that amendment on before we break for the year, so it'll be available to the public.
I'll tell you what we'll do. We'll roll it to the hill of today's calendar. Without objection, roll to the hill.
Thank you, sir.
Item 16, House Bill 240, Representative Hardaway.
Thank you, Mr. Chairman. I have a witness for that. In fact, the witness is one who inspired the legislation itself. The witness is not here today. I didn't think we would get to it today, but I think the bill is worth considering today, unless there's a cold wind blowing. Is it chilly in here? Roll. Looking for a sign.
I put a coat on this morning before I left the house.
All right. That needs to give the other one company at the heel, sir.
Item 16, House Bill 240, roll to the hill.
Mr. Chairman, number 17 is a bill that y'all know that sorry, we're not on it yet, are we?
Item 17, House Bill 689, Representative Hardaway. You are recognized on the bill.
Thank you, Mr. Chairman. This bill, as written, requires that an officer who responds to the stalking, aggravated stalking, domestic violence, sexual assault, etc., that officer would have information in the form of a simple document that would notify the victim of the availability of GPS monitoring that could be required as a condition of bail. And what does that do? That allows the alleged victim to be able to go about their lives without feeling like they have to be imprisoned because of the freedom of the alleged perpetrator. This is one that I've worked with Judge Carter on for quite a while, and I have some amendments that I don't think we need to consider those on this. I want this to be the same as it was last year. We got it to the floor, and we just didn't have time to get the family to be scheduled to come to witness the passage of the bill.
Question's been called. Any objection? Seeing none, we're voting to send House Bill 689 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move forward.
Mr. Chairman, out of appreciation, I'm going to ask that you run item 18, House Bill 688, to the Hill also.
Without objection, roll House Bill 688 to the Hill.
Thank you. Thank you, members.
Members, we're going to go back to the Hill of the calendar and pull up one that we sent down there. Item 13, House Bill 908 by the Vice Chairman Gillespie. You are recognized. There's an amendment code 4333. Do you wish to proceed with that amendment?
Yes, and that amendment makes the bill, Mr. Chairman.
All righty. Without objection, we'll go ahead and vote to attach this. All those in favor attaching amendment code 4333 on the House Bill 908, please say aye. Aye. Those opposed, ayes prevail. You adopt. We're on House Bill 908 as amended.
Thank you, Mr. Chairman and committee. So this is my third time in 3 years coming before y'all with similar legislation. In my part of the world, drag racing and reckless driving just continues to be out of control. This past weekend, we had an incident where a 6-lane street in the middle of Memphis was completely shut down for about 3 hours. There was another incident this weekend that actually shut down another intersection that stopped a fire engine in its tracks that was responding to an elderly person in distress. The situation continues, even though we have been very successful in passing legislation in years past addressing reckless driving and drag racing. And what this bill will do is it will allow the seizure of the vehicle used in drag racing on the front end. The reason why this is important and the reason why I'm taking such a drastic step is last year we had some 300 arrests for drag racing, and not a single one of them was actually convicted of drag racing. The problem continues. It is plaguing us. I'm honestly shocked that we're not seeing more deaths and casualties as a result of this. A couple years ago, there was another instance where Interstate 240 was stopped and an ambulance was waiting to get to Baptist East Hospital at the Walnut Grove exit. Had that ambulance been carrying a patient, that patient would have most certainly have died. I'm sure there are hundreds of other situations across the state just in the past month where this is happening. It's scaring my constituents simply leaving their driveway. And with that, I welcome any questions and would love to go into as much detail as you possibly would like to. Thank you very much.
Thank you for your explanation, Representative Davis.
Thank you, Chairman. And thank you, Representative. I have a question with regard to the amendment in Section 4. It says that the vehicle must be destroyed. It is not subject to sale or use by a state, county, or municipal agency. Would you be willing or open to amending that language to where the car would be sold, but those monies would go to a traumatic brain injury fund, similar to what we do for DUI?
Thank you, Mr. Chairman. Representative, yes. I mean, I'm at the will of the committee. Anything that we can do that tackles this, I'm all ears.
Chairman Olsey.
Thank you. And we haven't put the amendment on yet, but
I did.
The civil side of this thing, I've never liked civil asset forfeiture ever. Always been opposed to it. To me, it violates the Fourth Amendment. And then if you can find criminal charges, you jump out of the civil side and jump into criminal charges so you can charge them. I would much rather if you came back around the other side and made it a criminal offense, and then the criminal offense is drag racing, then there's a criminal forfeiture on that side for you to consider. But that's me. I've always opposed civil asset forfeiture.
Thank you, Mr. Chairman. And Chairman Halsey, there is already, we already have that ability, and that's, I think, the problem. It's not working. I think the arrests last year proved that it's not working. I've had multiple conversations with some DAs, both Republican and Democrat, and I don't really know that increasing the penalty for drag racing at this point is the solution, because at least where I live, what we're having is people driving $80,000 to $120,000 cars and going 120, 130 miles an hour down a inner city street, and they get slapped with a $2,500 fine, and they gladly pay it and move on. If we take their vehicle on the front end, I think people will really take notice, and that's what law enforcement and DAs are telling me.
Representative Campbell.
Thank you, Mr. Chairman. Not too many weeks ago, a colleague and I were walking near the Nashville Public Library. I recognize this was not drag racing, but there was a car that went in the dark of the night or the evening, went through a red light at where buildings are. You cannot see through the buildings to see if any traffic's coming. You should not run a red light anyway, but I cannot guess how fast this car was going, and we're lucky we didn't eyewitness a fatality. Thank you.
Thank you, Representative Campbell. I completely agree with you, and I also, I may be making a controversial statement here, but I believe bad behavior drives other bad behavior in these cases like this. So when you have people that are acting reckless out there getting away with that behavior, I think that they then see that and say, well, we can street race as well because no one's going to stop us speeding. And so I think that's a very, very excellent point, and I believe this would help with that.
Leader Lamberth.
Thank you, Mr. Chairman. And I was talking to Chairman Halsey over here for a moment. I think one important part of this is that this, while in the civil asset forfeiture section, requires that a motor vehicle used in the commission of a violation of subsection A, which is 5510-502. So this is criminal asset forfeiture. It's not, civil in nature as if it's disconnected or unhinged from a criminal activity. It's going to have to be used in the commission of a violation of drag racing. So unless they can prove that it's used in drag racing, the vehicle's not going to be forfeited. And I share my friend Representative Davis's advice that the vehicle be sold to the Traumatic Brain Injury Fund. These crashes hurt people, sometimes folks that are involved in drag racing, sometimes folks that are just innocent bystanders. And that fund, I think should be replenished by the very folks that are causing some of the damage that is out there. So just wanted to bring that up as far as the asset forfeiture part of it. We've just about killed civil asset forfeiture in this state, which is a good thing. It is criminal asset forfeiture now, unless you can prove that this vehicle was associated and, in fact, used in the commission of drag racing. Nobody is going to be able to seize or forfeit that vehicle, which is a good thing. So I like those protections in there.
Representative Hardaway.
Thank you, Chairman. And this might go to the sponsor or to Leader Lambert. I was having a difficult time understanding the sponsor saying on the front end that the forfeiture would be on the front end, and I'm not following that.
Sponsor.
Thank you. Representative, what I meant is just exactly what Leader Lampert just said. He just put it a little bit clearer than I did. He is an attorney and I'm not.
Oh. I'm good. Thank you.
All right, thank you. Representative Towns.
Mr. Chairman, I think the bill is timely. I had a bill like this 5 or 6 years ago to deal with this kind of behavior throughout our streets within the city, on the expressways, on the highways. I saw something coming up on the way. The guy had to be doing 120 miles an hour, because they come out of nowhere like a bat out of hell and they zoom by. It's a problem. And the only problem with this bill, what I had included in there, is that you take the car, give them some jail time, and you suspend their license too. And the licenses are actually activated once they completed their jail time. These are serious infractions that can maim people, kill people. It's frightening when somebody comes behind you doing that kind of tremendous kind of speed. We have to do something to get these people's attention to prevent this kind of behavior. The streets belong to everybody. It has to be a civilized, process in order to drive going forth to work. And God forbid, as was indicated, someone transporting a patient. And these sapsuckers are playing on the streets and preventing people from getting by, or your house is burning, or there's been a shooting, or something of that nature. And these numbskulls are acting a damn fool on the highways, preventing folk getting through to take care of some business. Something needs to be done to them, and it needs to be done quick, fast, and in a hurry. It's just that simple. Taking a car is gentle. You need to do something else to them as well. They have no right to tie up the streets like that. Nobody does. So with that, I'm supporting the bill.
Representative Gillespie.
I'm up to the committee here if we want to make that amendment. I don't know what the procedural is there, but I appreciate Representative Towns' support and I motion to. I renew my motion.
All right, thank you. Chairman Halsey.
I was just going to make one other observation. The leader and I were discussing the fact that second conviction, you can lose your license forever. I have one other problem, and that generally drag racing with no accident or no wreck is a Class A misdemeanor. If a man's driving a $25,000 car and you take it away, that's a pretty daggum big fine for a Class A misdemeanor. I wish there's another way to fix it.
Previous question has been called. Any objection? We're objecting, so we're now voting on previous question. None on previous question. He withdraws. All right. We're voting on sending House Bill 908 as amended to full criminal. All those in favor say aye. Aye. Those opposed? No. The ayes prevail. If you wish to be recorded as a no, see the clerk. Item number 14, House Bill 830. Representative Gillespie. Motion. Second. You recognize there's an amendment code 4436. Motion. Second. You're recognized on the amendment.
Thank you, Mr. Chair. This amendment also makes the bill,
All right. We'll
and it
attach-
actually does.
All right, thank you. We will attach, without objection, 4436 on the House Bill 830. All those in favor say aye. Aye. Those opposed, you adopt. We are on House Bill 830 as amended. Representative Gillespie.
Thank you, Mr. Chair. This bill's amendment deals with admission to bail for a defendant accused of committing certain criminal offenses. First and foremost, under present law, any defendant may have bail set by magistrate, judicial commissioner, or court clerk, or judicial sessions court, or trial court judge. This bill would restrict the sole authority of magistrate or clerk to release a defendant accused of a Class A or B felony on his own recognizance, and instead require the approval of a general sessions judge or trial court judge to do so to release such defendant. Where this is coming from is we have a revolving door in our criminal justice system. Back in Shelby County, there are police officers that will arrest the same people for violent felonies in the same day in some cases. I know that's hard to fathom, but it's true. And what this intent is to give oversight to the people that you can elect. Allow the transparency to know who they're releasing from jail on bail, when they're doing it, and if you don't like it, you can vote them out of office. We're not changing any of the bail requirements. We're not doing anything like that, except for if it's a repeat offender. If the person is already out on bail for another offense and they get rearrested while they're out on bail, it just sets up a little bit more parameters for them to pay a little bit higher bail amount instead of using that original bail. And with that, I welcome any questions.
Representative Johnson.
Thank you, Mr. Chair. I guess my question here is that I totally understand that magistrates aren't, setting the right amount of bail. However, if this is turning that over to these other judges that are already far backlogged, then we've got another bill coming up that also puts a massive load on those folks. Is there something that we can do to make sure that the magistrates are putting appropriate bond amounts on rather than sending it over to another group of judges who really don't have room on their dockets for this stuff?
Thank you, Mr. Chairman. I'm probably to make people upset on this comment too, but back home we have a great group of judges that currently are telling us that they're overworked when they're working about 10 a.m. to 2 p.m. every day. That's not a full work schedule, and I'm not attacking them in any way whatsoever, but I will say that is part of the problem that we're facing. And when we have these unelected judicial commissioners that no one in my community knows who they are, doesn't know their first or last name, and has no recourse, and they're making decisions like letting out someone accused of first-degree murder out with no bail whatsoever, that's a problem.
How do they get put in those positions?
Sorry, who?
The magistrates.
The decisions of releasing people? Oh, yes. The county commission appoints them, and ratherly, at least in Shelby County, it's no one knows when one appointment is up or when it happens or the communication. So, again, you're not going to fire the entire county commission. So this is a solution for that transparency and accountability.
You can put pressure on the county commission. You do not have to fire them. We are going at a problem as if there's only one solution, where there are multiple solutions here, and it sounds like you need to really make sure and have pressure to appoint folks who know what they're doing and are accountable to the people. But to bog down folks that you say don't work, and perhaps I'll say that they spend a lot of time not in the courtroom preparing. I'm not going to tell that someone else is not doing their job. I know that those things take a lot of preparation. But it just seems like there's a smarter way to go with this because some folks are not doing what's right. Whoever appointed them needs to reappoint.
Representative Hardaway.
Thank you, Chairman. And I'm trying to support my friend, but I've got to push back on the comment on judges being lazy and not showing up for work. I know a few judges, and I know all judges don't have the same work ethics, but the majority of the judges that I know do work before court, do work after court, on weekends, Saturdays, Sundays, etc. We have a backlog, a great deal of that backlog. There have been studies which indicate that we just need more judges. So that needs to be the answer to the backlog. I'm willing to look at the modification of the bail process, but I got to push back a little on the appointment of magistrates. That information, like everything else that's on the county commission calendar, is made public in advance. Individuals are nominated, they're vetted in public by the county commission, and if you don't like them or don't think they're qualified, you've got every right to show up and speak against them, hold the members of the county commission that vote for them, hold them accountable next election. So I've got to push back on that portion of it. But the idea that we've got to have folks setting bail who can be held accountable directly by the public, I agree with that. I just don't agree with some of your statements and this approach. So I'm with you on your purpose, but not necessarily on your plan. Thank you, Mr. Chairman.
Leader Lamberth.
Move previous question.
Previous question's been called. Any objection? Seeing none, we're voting to send House Bill 830 as amended on the full criminal. All those in favor say aye. Aye. Those opposed? Ayes prevail. If you wish to be recorded as a no, please see the clerk. You move on to full criminal. Item number 19, House Bill 1285 by Representative Eldridge, off notice. Members, we're going to go out of order. Go with me to item number 38. Item number 38, House Bill 403 by Leader Lamberth.
Thank you, Mr. Chairman. There's an amendment that makes the bill, Amendment Code 6269.
We'll need a motion and a second on the bill. Second. Motion and a second. There are two amendments. Which amendment code do you wish to proceed with?
6269, Mr. Chairman. That should be the only amendment we would need.
You have a motion on the amendment and a second. Second. You're recognized.
Mr. Chairman, members of the committee, this is in essence the same bill we passed last year to put guardrails and qualifications on the Delta 8 product that is sold out there. Makes it where it's only sold to those over 21. And I've worked with members throughout the industry, both last year and this year, to ensure that we put some safety protocols in place for this particular product.
Thank you for the explanation. Any questions for the sponsor on the amendment? Seeing none, we're now voting to attach Amendment Code 6269 on the House Bill 403. All those in favor say aye. Aye. Those opposed? You adopt. We're now on House Bill 403 as amended. Any questions for the sponsor? Chairman Halsey.
I was just going to verify that the Department of Ag is actually over the enforcement and all that deal, and also the rule making. I think that, and that's a good thing. Just want to clarify that.
Leader Lamberth.
Yes, Department of Agriculture and Revenue both have different authority for enforcement on this and rulemaking. It files primarily with Ag, but some of it is in Revenue as well. Thanks.
Question's been called. Any objection? Seeing none, we're voting to send House Bill 403 as amended to full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move forward.
Thank you, members of the committee and the chairman.
All right, let's go back, members, to item number 20. Senate Joint Resolution 35 Representative Reagan.
Thank you, Mr. Chairman and committee. I bring you a proactive
We need a motion
bill,
in a second. You're recognized.
and I will point out this bill passed out 8-0 in the Senate committee and is on their consent calendar, although what they do in the Senate doesn't affect what we do. And I will also add, unfortunately, the good leader has left, but he informed me that the American Law Institute's code is something we don't use in Tennessee, but this resolution is proactive to prevent that from happening should at some future date this happen. And the reason, quite straightforwardly, is Article 213 of the Model Penalty Code, Penal Code of the American Law Institute pertains to sexual assault and related offenses. Unfortunately, in my opinion, Article 213 of this code mandates hiding of sex offender registries, and as you all likely know, all 50 states in the United States have publicly available registries, including Tennessee. Secondly, and most heinously in my opinion, it adds a remarkably anti-victim change for a crime that is unmistakable. It adds a defense of age knowledge. In other words, the defendant can claim that they didn't know the victim was underage and use that as a defense. And frankly, that's one of the primary reasons that I agreed to run this resolution in the House. As I noted, it's already passed in the Senate. In summary, I ask for a favorable vote on this Senate joint resolution from Senator Wally. And I stand ready to answer questions. Thank you.
Thank you. Representative Moody.
Thank you, Mr. Chairman. Thank you for this, Chairman Reagan. We passed a law in the human trafficking realm that said they could not use ignorance of age as a defense. So I wholeheartedly support this joint resolution. Thank you for bringing it.
Thank you.
Any other questions for the sponsor? Seeing none, we're now voting to send Senate Joint Resolution 35 on the full criminal. All those in favor say aye. Aye. Those opposed? You move forward.
Thank you, Mr. Chairman and committee.
Thank you. All right, let's see here. Good friend, Mr. Representative Carr, House Bill 458, item 51. You are recognized. There's amendment code 3460. Do you wish to proceed with that amendment?
Thank you, Mr. Chairman. That is the amendment that makes the bill. And
you are recognized on the amendment.
Thank you, Mr. Chairman. As I said, this bill, amendment makes the bill, and this is the boating under influence. It's putting the law back like the driving under influence. 7.4% of our fatal boating accidents in Tennessee in 2019 were the cause of boating under influence. And the Coast Guard reports that's about 23% fatal boat accidents were contributed to alcohol use. And most of research indicates that alcohol is likely underreported in Coast Guard boating accidents. Additional researchers have found that 55% of fatal boat victims in Maryland and North Carolina tested positive for alcohol. And also it's been a problem upon some of our area lakes, Douglas Lake being one that I'm closest to. And so therefore we're just trying to make the law mirror what the DUI is, and then we're calling this in the BUI, boating under influence.
Thank you. Leader Lamberth.
Thank you, Mr. Chairman. And Chairman, I know we've talked about this bill. I absolutely love the bill. Whether you're intoxicated in a vehicle on the roadway or a boat out on the waterways, it's extremely dangerous. We've had some deaths in our community as well, and this bill definitely needs to pass. I will say the only thing that we caught in just kind of looking at this bill is pretty deep in your amendment in subsection 5. There's a reference to metropolitan forms of government in population of $500,000. Apparently, you can get 200 hours of community service instead of 48 hours. Well, that's not equal justice in my opinion. I know there's nothing we can do to fix it right now in subcommittee, but would you be open to an amendment between sub and full? That's leftover language from the current statute, and I'm going to be looking for ways that we can take that out of the DUI law as well. But just because you live in a certain part of the state doesn't mean you should get a discount for criminal behavior. It should be the same throughout the state.
Yeah, yes, sir, Chairman. I would welcome that. Yes, if this is passed out of here and goes on to the full, I would consider that a friendly amendment.
Representative Howell.
Thank you, Mr. Chairman. Just for clarification for the sponsor, As I read this, I don't believe the amendment makes the bill. I believe it rewrites Section 4. Am I incorrect on that?
That is correct. The amendment
You're right.
does rewrite Section 4.
Yes, it's correct.
Thank you very much.
I stand corrected. That's correct, yes.
Any other questions on the amendment? Seeing none, we're going to vote now to adopt Amendment Code 3460 onto House Bill 458. All those in favor say aye. Aye. Those opposed? The adopter on House Bill 458 is amended. I think you pretty much explained the bill already. Is that?
That is true, and I appreciate Chairman Howell, because I've got it right in front of me, it's Section 4, but I said it made the bill, but it does not. The bill in itself.
Any other questions for the sponsor? Well, Chairman Halsey, go. You're recognized.
Thank you, Mr. Chairman. When you first came up with this before,
yes, sir,
there was an issue of marrying up the reporting system so that if you were convicted of a DUI on a boat and then within 10 years you got, convicted of a DUI in a car, that would be your second DUI. I haven't kept up with you. Did that get solved where those two systems are married together and an officer can pull up whether this is your first or second DUI?
Mr. Chairman? Yeah, I cannot answer that truthfully. I was hoping that it did. We made that as the intent. Does it? I think it does that, but I want to clarify that for sure.
That passed last year.
Okay, thank you.
Any other questions for the sponsor? Seeing none, we're now voting to send House Bill 458 as amended to full criminal. All those in favor say aye. Those opposed? Ayes prevail.
Thank you.
Move forward.
Thank you, Committee and Chairman.
Item 22, House Bill 1109, Representative Travis. You are recognized.
Thank you, Mr. Chairman and Committee. The House Bill 1109 does one thing. It amends Tennessee Code 3913-306, and it says to harbor or hide a child within or outside the state, knowing that the child has been placed in the custody of the Department of Children's Services pursuant to a protective custody order or an emergency custody order entered by the court. That's what we're adding in the code.
Thank you for that. Any questions for the sponsor? We do have guests here to testify today. So we do. We are properly on the bill. All right. Without objection, we'll go out of session. We have one testimony here today, Ms. Connie Regelli.
Thank you.
You will have 3 minutes for your comments, if you will. State your name and.
Yes, I would like to. I have brought copies of the legislative history. I would, if I could just pass them.
No, ma'am. We won't be able to accept them. No, ma'am.
Okay. All right. Well, I'll just go through those.
You are more than welcome to hand those out to the members once we leave the committee today or drop them by their office.
Sure, I will be happy to do that.
Thank you.
All right, so my name is Connie Regularly, and I've worked with families who've struggled through the Department of Children's Service investigations for about 3 decades, and there are some problems with this bill. And if you look at the legislative history, you'll find that in 1989, when the criminal code became a statute, there was really kind of a very broad custodial interference. The important thing for you to know is in 2002, the General Assembly came in and really narrowed that bill. And in particular, if you look at it, it is custodial interference is an action between family members who have had the ability to go to court, fully adjudicate custody, visitation, etc., so that by the time the order comes down, everybody's had their day in court. And everything in that bill is about family members. So what this bill will do is it now expands that, and most egregious and concerning to me is the fact that DCS can take anonymous reports and initiate an investigation, and they could even take that anonymous report, take it straight to court, get a removal order without the parents even having participated in an investigation. So this really smacks of due process concerns when you have the ability to go forward with those. This does not even require service. If the bill were amended to say that upon the completion of an investigation, upon service to the parent, and their ability to be heard, then it would make much more sense. But as we sit here today, it allows them to take an anonymous report, go to a judge and get a removal order ex parte in secret, and then have a parent arrested if they don't turn a child over. And I have seen DCS make these, take these anonymous reports and do so. So I would ask, as it stands, that we don't pass this bill. Thank you.
Any questions for our guest, Representative Hardaway?
Thank you, Chairman, and thank you for being here, ma'am. What language in what part of the bill are you suggesting needs to be changed?
Well, that it just needs to say, I've got a copy of the bill here, that it needs to say upon the completion of the investigation, that it's been served on the parent and they've had their opportunity for a hearing in court. Now, DCS, remember, if it is child abuse or neglect, they can get a criminal warrant if they have probable cause of neglect or probable cause of child abuse as a criminal violation. They certainly could arrest a parent for that. So it needs to be investigated, served, and the parents have their day in court.
And the difference in what you're proposing and current law, not talking about the bill, and current law.
So there's no custodial interference for DCS at all under current law. They can get a contempt of court, they could get a child abuse warrant, they can get a child neglect warrant, but custodial interference, as it is written and as it was very carefully crafted in 2004, is about family members and divorce and custody and paternity situations where everybody's got a full and final order.
So current law is about contempt of court, more so than anything else.
Well, both would be about contempt of court. Even the new proposal is basically a contempt of court. But the reason they did the custodial interference criminal is because, between family members, is because if they would have to, let's say, if a parent violates a custody order, a fully adjudicated custody order, and they need to be able to arrest that parent to get the child. So of course they could do contempt of court, but it wouldn't provide an opportunity for law enforcement to get involved, because law enforcement cannot get involved in criminal contempt.
All right. Thank you. Thank you, Chairman.
Chairman Halsey.
Thank you, Mr. Chairman. Thanks for being here. You are correct. The existing law deals with custodial interference between parents.
Correct.
If you've got a civil order and it's tied to a civil order where a judge says you've got custody and a non-custodial parent takes the kid away and says you can't get him back, that's custodial interference under current law. But I met with the sponsor because I was concerned about the same thing, and he assures me that the way the bill's written, that a parent would have to be served with an order or a warrant or a piece of paper before this process could take place, which would seem to be, due process to me. How do you read that?
Sure. Well, the language that I have in front of me says it is not a defense that the person harboring or hiding the child has not been served with an actual copy of the protective order.
Yeah. Yes. So the issue would be if DCS has told the parent, then they were notified. Even though they don't have the paper?
Well, the statute doesn't define what knowing means. So what is that proper notice for them to have? Because it doesn't, it just says knowing that the child has been placed. So we don't know what that means. Did they leave a postcard on the door, that they send them a text message, that they left a voice message, that they called somebody else? We don't know. They leave something at the school.
I agree with you in the sense that I don't want the state having arbitrary power to just invade a home and take custody of a kid without a due process for parents. Now, but most of the time under an emergency commitment, you know, the situation has been investigated by somebody, at least at the place that it rises to an emergency removal of a kid. And I want due process for parents. I don't want the state having arbitrary power to inject themselves at will. But I might have questions just for the sponsor to cover some of that.
Right, that is correct. That is correct. But the part of the investigation is vague, and although DCS has requirements to investigate, they don't always go and do a proper investigation. So they can take that anonymous report and get an ex parte order.
Thank you. While we're out of session, I'm going to go over to legal for some explanation/clarification here.
Michelle Fogarty, Legal Services. The term knowing is defined in Title 39 under 3911-302. It's defined as referring to a person who acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct. And in regard to custodial interference, the bill adds a subdivision 6 to subsection A, which states that it is an offense of custodial interference for a natural or adoptive parent, step-parent, grandparent, brother, sister, aunt, uncle, niece, or nephew of a child younger than the age of 18. So it would apply to those persons. It would be an custodial interference for them to harbor or hide the child within or outside this state, knowing that the child has been placed in the custody of the Department of Children's Services. The last sentence of the bill states it is not a defense to a violation of this subdivision A6 that the person harboring or hiding the child has not been served with an actual copy of a protective order or emergency custody order. Some of those persons to which subsection A applies may not be a party to the custodial action. So that I can't speak to the intent of the sponsor, but if you're not a party to the custodial action, I don't know that there's a requirement that you be served.
Thank you very much. Any other questions for our guest or legal services while we're out of session? Representative Hardaway.
Thank you, Chairman. I thought I was with you. And you may not want to take it in this form, but is due process being observed?
I don't, that would depend on the facts of each individual case as to the parties to the action. If a person is not a party to a custodial action, I don't know that there's a requirement for them to be served with an order in that action. In other words, if a grandparent is not a party to the custody proceeding, there would be no requirement for them to be served with a copy of the court's order.
And they could be arrested?
If they were under subsection A, they are listed as persons who are part of the custodial interference, a grandparent, a step-parent, a brother, a sister, an aunt, uncle, niece, or nephew of a child. They would be committing the offense of custodial interference if they harbor or hide the child within or outside the state, knowing that the child has been placed in the custody of the Department of Children's Services.
And the difference in before this bill becomes law and now is just the involvement or the standing of the Department of Children's Services?
Actually, under current law, under subdivisions A1 and A3, it is an offense to remove a child from this state in violation of a temporary or permanent judgment or court order regarding the custody or care of the child, or under A3 to harbor or hide the child within or outside the state, knowing that possession of the child was unlawfully obtained by another person in violation of a temporary or permanent judgment or court order. So depending on the facts and circumstances, some of those could apply. It would depend on the facts of each individual case.
All right, thank you. Thank you, Chairman.
Representative Towns.
Mr. Chairman, thank you. Legal, in consideration of all you said, what if someone was trying to protect the child from brutality or molestation, and they took the child and hid him within the state or outside the state? How does the law look at that?
I think that depends on the exact circumstances of the case and who actually has custody and what other court proceedings are in play.
I thought that we had on the books, as a matter of fact, in law, that if we know or suspect strongly that a child is being molested, I'm going to add in, physically abused like that. We were compelled to do something about it, even if it be a teacher or someone. I don't know legally what the TCA specifically state, but that was my understanding, that we are forced to do something about it, reporting it and trying to do something about it. And I can see a parent, if they know the child actually is being molested, that they would take or go to drastic lengths and measures to try to protect that child.
There are mandatory reporting statutes for child abuse and child sexual abuse, yes, sir.
But mandatory reporting.
Reporting to DCS, yes.
But I'm talking about also further than reporting, actually taking some actions to protect that child. If a child's supposed to go to this person A's house this weekend, and you know that is something that's going on, would you allow that child to go to that house? I would not. I would not, because of the abuse, the things that could happen, the things that will happen or may have already occurred. So I'm thinking that mandatory would address that as well. I'm just asking, how does that stack up to what we're trying to do here now?
That person would have the ability to go to the court and obtain an emergency protective order.
What if it's a Saturday evening, Sunday?
I suppose they could report it to the DCS hotline, 24-hour hotline, and then DCS would investigate and proceed along their normal procedures.
Okay, thank you.
Thank you. All right, anyone else? Thank you very much for your time. We're going to go back into session. Representative Travis.
Thank you, Mr. Chairman. Again, this is another level of safety for our children. It is adding a code to harbor or hide the child within or outside the state, knowing that the child has been placed in the custody of the Department of Children's Services pursuant to a protective custody order or an emergency custody order entered by a court. The process is here in the books. It's already in the books. This is just adding, hiding, and harboring to that section.
Chairman Olsey.
Thank you, and thank you, sponsor. You and I sat down and talked about this because there were some folks that had some concerns about it. Based on the testimony that we heard, right now you can call in anonymously on a child abuse, child and neglect thing, and DCS goes out there. Sometimes police go with them. Sometimes police go out there. Then they make recommendations, and they can go to a judge and ask for a removal. In that process, I'm assuming the parent would know that something's going on. Her concern is that anonymous call goes into DCS. DCS takes that information and makes an arbitrary decision and goes out there and goes to the judge and gets a warrant without any investigation to take the kid out of DCS, and if the parent knows that's coming and then leaves, they're guilty of what your bill says they're guilty of.
That is correct, sir.
That's her concern. Is that possible under your bill?
No, I mean, if it's a court order, to protect that child, the parents know that. The parents know something. Yeah, if somebody makes a hotline tip or something like that, that is investigated. It's still investigated today, with or without this bill. We're just saying harboring or hiding a child, you cannot do it, or you're going to be with a felony offense, an E-felony.
Okay, just for the record and for her concern, how does the parent know when the court has awarded temporary custody to DCS under the way current things operate now? How does a parent know that? Because I can't remember how we used to do it. Once we turned it over to DCS, I really don't know what happened.
But I think, do we have someone for DCS in here? Can we call up Jim? Will you come up and answer that question for us? If it's all right, Chairman.
That'll be fine. He's on the list. We'll go out of session.
Thank you, Chairman and committee members. Jim Lehman, Legislative Director for the Department of Children's Services. The department has a position of defer on this legislation, but we're happy to answer any questions you may have about it.
Yes, sir. My question before, I can't remember how we used to do it. It's been a while. When DCS gets a referral and they look into alleged allegations of whatever they are, and they go in front of a judge or ex parte to clerk's office and says, we want a removal of this child. On how you do business now, how does a parent know that that judge has granted that, other than the police showing up at their front door with DCS workers saying, I'm sorry, we come to pick up your kid? How does a parent know?
Sure. Well, I think that would be a case-by-case basis. I can get some more information on that specific question. I would say specifically about the anonymous reporting issue, there was a bill that Chairman Doggett had last year that passed that was specifically about we will not go to the court with solely an anonymous reporting and ask the homeowner to enter the home based solely on an anonymous report, that we would have to have some other evidence in order to go into the home. So I don't know if that answers your question at all. It seems kind of on the topic there. But as far as your first question, I would have to ask him. Sorry.
Okay, if the judge was going to remove a child, somewhere in that process, the parent's got to know to violate this bill, the parent has to knowingly know that there is a piece of paper out there that wants my kid. They've got to know that at some point if they're going to violate this law. When do they know that?
Sure. Again, I think that would be fact dependent, but again, as legal said, knowing would be in the bill, I believe, and so they would have to, have knowledge, like you say. I mean, in order to meet the definition of the bill.
Would that come from service of a piece of paper?
Yes, if they're a removal, yes, that there should be service.
Representative Towns?
Yeah, knowing to me, if you have two people are in conflict about a child in the custody, and one says one thing, and somebody else says something diametrically opposed to it, I mean, people lie all the time. So knowing if it doesn't come from the state or something of that nature, it's not official. I don't know unless I get a document, because I'm not going to necessarily, if I'm at odds with that parent, the other parent, I'm not going to necessarily believe them. So how do I know? I don't care what they said, he or she said, because that is not official to me. So I don't know. I may have a hunch, but I don't officially know. When people are going at it, they go, I mean, it's almost become like a blood sport. Okay, so how do you address typically, accurately, knowing? How does the person know?
Chairman, well, I think the bill is about knowingly violating orders, right? Not knowingly just disagreeing with something. You know, I think the bill is about, regardless if you disagree, the correct recourse isn't to just harbor a child or run off with a child. The correct recourse would be to go through the court system and not knowingly violate orders. And the bill would punish that knowing violation of orders. Yeah.
I'm good, Mr. Chairman.
Representative Hardaway, briefly, we have to leave the room here in just
Yes, sir.
like right
Thank
now.
you. And DCS? Yeah. Can you just briefly restate how the parent would be notified? How many different ways the parent could or should know?
Know that their child has been removed from their custody, or
Correct.
Typically there would be a court order. I know the bill does contemplate the possibility that there may not. Yeah, sorry.
Ex parte.
What's
Is that possible?
I would have to ask Representative.
All right.
I'm not
Thank
sure.
you. Thank you, Mr. Chairman.
I'll ask on that.
Thank you. We'll go back into session.
Thank you, Mr.
Representative
Chairman.
Travis.
Again, you know, we have a child custody place named after Landon in my hometown, who was made to drink dishwashing liquid and eat cigarette butts, and the doctor said he was kicked like a mule before he died. That is what we're here to do, is protect the children. The parents will know what's going on with this. They know if it's a court order, they know what's going on. So to protect the children, I renew my motion about the harboring and hiding a child.
Thank you, Representative Johnson. Brief question.
Thank you, Mr. Chair. Yeah, it just goes a little bit more in depth. I think I understand you're pretty clear that parents are definitely going to know. I'm curious, is the notice when they come pick up the kids, or is there some sort of advanced notice? And have they had the ability to bring evidence against the claims against them?
Yes, sir. Yes, Representative. That is not changing in the bill. So this is the documents right here. That doesn't change. Nothing's changed on how they're notified or what court they have. This is just saying that if that child has been moved by emergency custody to the DCS, then you cannot harbor or hide that child while that is going on.
Okay, but can you tell me that are they just getting the notice as they're picking up the children, or is there some advance notice?
I do not know how that works, advance notice or anything like, I don't know what the procedure is going forward on that. I'm just here to say you cannot harbor or hide that child while this is going on, and move out of town, make an Amber Alert that was done 4 months ago when somebody run off with a child.
All right, any other questions? Seeing none, we're now voting to send House Bill 1109 on the full criminal. All those in favor say aye. Aye. Those opposed? Ayes prevail. You move forward. Thank you, Mr. Chairman. Members, all remaining bills that are here on the calendar will pick back up next week. I apologize for all of you that have been here waiting to hear a bill heard, but we will see you next week. We are adjourned.
Thank you, Mr. Chairman. No. Yeah, you talked all.